people of the state of Michigan versus Shane Leroy Raymer. Leroy or Leroy?
Leroy.
Yep, okay, I like Leroy. File number 23-21665FH. I have Brenda Underwood, P41009, appearing on behalf of the defendant, and I have Dan Gumto, but state your full name and your P number, please.
Your Honor, Nicholas Sears on behalf of people. Nicholas Andrew Sears. I am appearing under Michigan Court Rule 8.120, I believe, which is the observation of waiting for my bar results.
Okay, very good. All right, you had your hand up?
Yes, I fired her due to misrepresentation.
When did you fire her?
Over 2 weeks ago.
Was that in front of me?
No, that was in her office but the reason I fired her.
Well, do you have another attorney?
I will represent myself.
You're gonna represent yourself.
Yes.
You know, there's a very famous quote about representing yourself. Do you understand that?
Yes.
That, you know, do you have a law degree?
I don't need a law degree.
Do you have a college degree?
I don't need a law degree.
Did you graduate from high school?
I don't need that either.
You don't need that to represent yourself? Okay, do you have access to, okay, so.
I have evidence that shows that the description did not match. And
well, I'm not gonna get into that yet. So you're asking me today to remove Miss Underwood as your attorney?
yes, yes,
And you wanna represent yourself?
if I
Do you understand that even when I have court cases, I hire an attorney to represent me?
Well, I can't trust anybody in this system in this area because they all seem to be working together. This case should have been resolved a long time ago during the appeal the first time. She should have objected when the claim was made that I matched that description 100%.
Okay, so Mr. Reamer, part of what you're saying shows to me that you don't quite understand how the court procedures work, okay? So your attorney has an obligation to ethically represent you. And so before I would have clients come to me and say, I want you to file this and I want you to file that. And I would say, there's no basis for that. And I don't file frivolous motions, or I would say to them, they have probable cause or whatever. So if you want to represent yourself, you can do that at your own risk. You have the right to represent yourself. But what I will tell you is that Miss Underwood is the bane of most prosecutors' existence because she's a little pit bull and she doesn't put up with a lot of guff from them, and she's a tough defense attorney. So you may not like what she says, but I feel like she's always honest. So that being said, if you want to proceed and represent yourself, you can. But you understand you're going to have to file written motions. You're going to have to follow the court rules.
This is the trial, right?
No, it's a pre-trial.
How is this not the trial? I was told this is going to be the trial. I'm supposed to be sitting here with a jury today.
No, you're not.
Yes,
you're Mr. Raymer, I schedule jury trials and I haven't scheduled you a jury trial yet. Oh, wait, you're the one that didn't show for the pre-trial. That's why. Is that why?
Your Honor, if I could speak for a second, I think the first thing we need to do.
I'm sorry.
The bench warrant.
Yes. So Mr. Raymer, you failed. Yeah, he failed to appear for the pretrial conference.
That's correct.
All right. So everybody stop talking for a minute. So Ms. Underwood, thank you for reminding me of that. Mr. Raymer, you had a final pretrial conference on December 11th, and we gave you a notice of hearing, and you failed to appear for that pretrial. And because you failed to appear for that pretrial, I canceled the jury trial because it cost me a lot of money to have a jury here. And so if you're not here for the final pretrial, I'm not going to trial until I get you here. So I actually issued a bench warrant for your arrest for failure to appear for the pretrial. Do you understand that? So Ms. Underwood's now asking for me to set aside that bench warrant. Is that what you said?
Thank you, Your Honor. He did demonstrate to the court that he can show up by showing up this morning.
Okay. So Mr. Raymer, so Ms. Underwood's asking me for me to set aside the bench warrant for your failure to appear on December 11th. Do you understand that? Speak.
Yes, ma'am.
All right. And Mr. Sears, any objection to me setting aside the bench warrant since he has appeared today?
No, Your Honor.
All right. So Mr. Raymer, I will quash that bench warrant. And I'm sorry, I didn't look back to see that this was the original trial date. So that's my procedure. If people don't show up for a pretrial, I set the jury trial as the pretrial. Okay. Do you understand that? So that's why
Yes or
there's
no,
no jury.
Yes or no?
I did answer that.
So we're recording, so we have to hear you. So you have to speak up really loud, okay?
I said yes, ma'am.
Louder.
Yes, ma'am.
Okay, so Mr. Raymer, all right. So Ms. Underwood and Mr. Sears, this is a date and time set for pretrial. Mr. Raymer, I have your attorneys did file all the paperwork. Ms. Underwood, do you want to speak to Mr. Raymer for a moment?
Your Honor, I'm not sure that would do any good.
Okay. So
If
Mr.
Mr. Raymer would like to speak to me, I'm more than happy to speak to Mr. Raymer at this point.
So I'm going to quash the bench warrant. Mr. Raymer, if you want to sit down and talk with Ms. Underwood and see if you can meet a common ground, I would highly recommend that. You know, if you want to take 5 minutes or 10 minutes and talk to her, you can do that.
She's not been representing me appropriately.
All right. So do you understand you don't get another public defender?
Well, I fired her and I talked to this man. Are you Mr. Glacier?
No, that's Mr. Glazer.
Who was it that was in the office with us?
That was
That
me.
was Mr. Malero.
Okay, Mr. Malero and her why was he in the office when?
'Cause he's-
in the,
All right. So Mr. Raymer, if you are firing Miss Underwood, or I can grant that, but I don't have the ability to appoint another public defender to represent you.
no,
They are a
I-
separate entity.
If I can't get somebody to represent me that's doing the job appropriately, then I will represent myself. Because I can prove that I was not that person that they're claiming.
That's what a jury trial's for.
Yeah, and when it comes to the jury trial, then I will take care of it there. But I don't need somebody that's not gonna represent me appropriately.
Okay, well, I really doubt that she isn't appropriately representing you, but, so Mr. Glazier and Mr. Malaro, he's asking for me to, he's asking to fire Miss Underwood, so,
If I may, Your Honor.
yes?
Your Honor, I vetted Mr. Raymer's claims about Ms. Underwood's representation. My understanding, she conducted a preliminary examination. She also filed a motion to dismiss, I believe, that was heard and ruled on by this court. I've not determined that she's done anything that did not require, or that was not required of her. And so I denied Mr. Raymer's request to appoint a new attorney. For one of the reasons was that a trial date was imminent and it would be almost impossible for any attorney to get up to speed. Ms. Underwood is clearly ready to go to trial in this case. I think, as the court, I think, is aware, Mr. Raymer just doesn't like what he hears. So that is the reason I denied his request to have another attorney appointed in this manner, because Ms. Underwood's doing everything she can do on his behalf.
So Mr. Raymer, I guess I would ask, she held a preliminary exam, which is what you do to dispute the charges, and the judge ruled, whoever heard this, that there was probable cause and bound you over, right? Yes?
Yes, Your Honor.
And then she filed a motion to dismiss, is that correct?
Yes, Your Honor.
And I denied that.
Yeah, because you was.
What else is she supposed to do?
You was given false information. All she had to do is object and let it be known that I did not match the description of the person.
That's for a jury to decide.
No, that's for the.
Okay, well, I'm glad that you were trying to explain the law to me. So if you do not want her as your attorney, I will remove her
Yes,
as your
I do not
attorney.
want her as my attorney.
All right, so Ms. Underwood, you are relieved of your duties. So Mr. Raymer, you can either hire an attorney or proceed as you are. So I will get another jury trial date. Mr. Raymer, you will need to file with the court jury instructions and voir dire questions. And those are gonna need to be filed by a certain date.
And how do I go about doing that?
I can't tell you because I can't give legal advice. That's why you had an attorney. So you're gonna have to figure that out on your own.
Okay, well.
I can't give you legal advice as a judge.
That's all right.
That's what Miss Underwood was for.
But she wasn't doing her job.
She did do her job.
No, she
But-
failed.
I'm not gonna argue with Mr. Raymer. So Miss Adams, I'm looking for a trial date.
First available is April 22nd at 9 a.m.
Does that work for you, Mr. Sears?
Your Honor, that does work for the people.
All right, does that work for you?
Yes, sir.
Okay, so I'm gonna set trial for April 22nd of 2025 at 9 AM. And I'm gonna set a final pre-trial for, Ms. Adams, do I have April 9 available?
Yes, Judge.
So a final pre-trial for April 9 at 8:30 AM. So was there a plea offer made in this file, Mr. Sears?
Your Honor, yes, there was. Would you like me to place what the offer was?
I always do, yes. I keep that in my file. Thank you.
Your Honor,
You're not on this file anymore. Thank you.
Just 1 second while my computer, it is slow, Your Honor. It looks like the final plea offer provided from my office was 2 counts of an attempted RMO.
All right, so Mr. Raymer, do you understand the plea offer was to plead to 2 misdemeanors?
Yes, sure.
Okay, so those are 1-year misdemeanors, so it'd be 2 1-year misdemeanors in lieu of the 5-year felony, because you have, well, 4-year felony, police officer assaulting and resisting causing injury, and you have 2 2-year felonies for police officer assaulting, resisting, and obstructing, and 1 misdemeanor for disorderly person. Are there any body cams? Were those provided to Mr. Raymer?
Yes, I believe a discovery was sent to obviously the public defenders.
Okay.
If you would, obviously you would need any additional body cams or discovery, we would ask that Mr. Raymer come to the prosecutor's office and receive any discovery that he would want in person. Call ahead and they can get it.
Okay. So I'm going to set the final motion deadline for 4/9 of 25. And then motion limine for the same day as well. Jury instructions and voir dire questions will be due by April 2nd of 25. And so those must be filed with, you must provide a copy to the prosecutor's office of your voir dire questions and jury instructions, and a copy to the court on the 3rd floor of the clerk's office.
And that can be wrote out on a blank piece of paper?
No, they must be provided in full and filled out.
Okay, where would I go to get those forms?
There, you can do research on the computer.
All right,
I mean,
that's fine.
this is why, Mr. Raymer, when you're dealing with a felony and you're facing trial,
Yeah.
it's important to have an attorney. And it
Yeah,
doesn't
one
sound,
that's doing their job, yes, I understand that.
well, you haven't presented anything to me that says she hasn't done what she's supposed to do so far. So, Mr. Raymer, you know, there's no legal services available for indigent defendants other than the public defender's office. And, you know, you could hire an attorney, but these things are required. If you don't file them, then you don't get to add them the day of trial. Do you understand that?
What is that, the evidence? I don't get to add any evidence during the day of trial?
Well, you must submit it as exhibits and witness lists. Have you got to exchange those with the?
All the body cam would be considered already submitted, correct?
So you have to provide witness lists and a list of exhibits to the prosecutor's office, to my office, and then you must provide copies of that to them.
And where do I find your office at?
3rd floor clerk's office.
Okay.
Okay, but then you have to provide a copy to the prosecutor too.
Yeah, I'll
Okay.
probably head over there for you.
But by law, Mr. Raymer, I can't give legal advice because I'm a judge.
Yes, sure.
Okay. So, Ms. Adams, could I please get a copy of this from Mr. Raymer? And I'm gonna put little asterisks. Are you sure you do not want to proceed with counsel?
I would prefer to have counsel, but I don't want her representing me.
Okay, well, that's your choice, but your other option is to hire someone. Thank you. All right, have a seat back there and we will get you a copy of your pre-trial notice.
Yep. Okay. Go. Will you hand me my screen box?
Now go preach. Rah.
This is entitled Harry and Larry Richmond versus Cassandra Babcock and Curtis Webb. This is a damage hearing that was the previous subject of a possession judgment in this case. The parties were tenants of the Richmonds, and the Richmonds alleged that their property was damaged and that they suffered unpaid rent. Ms. Richmond, can you hear me?
Yes, I can.
Ms. Babcock, can you hear me?
Yes.
Mr. Webb, can you hear me?
Yeah.
Ms. Richmond contends that unpaid rent and other damage resulted in costs to them of $2,399.33. Ms. Richmond, I'm going to ask you if you'd please raise your right hand. Ms. Babcock, would you raise yours? And Mr. Webb, wherever you are, would you raise your right hand? Ms. Richmond, let's go through this.
Okay.
According to your security deposit notice to the tenant, rent was $2,517 through September 17th. Is that correct?
That's correct.
Ms. Babcock, do you accept that?
Yes.
Mr. Webb, do you accept that?
Yep.
Then they had to haul a dump trailer and 2 truckloads, $250. Treat for fleas and roaches 2 times, $120. Fill several large screw and nail holes throughout the house and repaint, $100. Repair front screen door, $30. Replace 5 missing window screens, $175. Is that all correct, Ms. Richmond?
Yes, it is.
As I've said before, your damage figures are always quite reasonable.
Thank you.
So you have total damages of $3,192. Is that correct?
That's correct.
And the deposit was $960.
Correct.
Ms. Babcock, do you agree at a $960 deposit?
Yes.
Mr. Webb, you agree?
Yep.
How about these other items? Hauling trash to the dump, fleas, screw holes, screen door, missing screens. Ms. Babcock, do you agree with those figures or no?
The front screen door was broken when we got there. That has been that way like the entire time.
We just replaced the screen. The screen was broken out of it.
All right, well,
Right.
just a minute. This is her chance to talk. All right, go ahead, Ms. Babcock.
Yeah, I'm pretty sure that had been broken the whole time. That's why we didn't use the door.
All right, anything else?
I didn't know about roaches and fleas. But that's.
There were dogs in here, as I recall, pit bulls.
I had one dog, yes. But I never had any issues with fleas, but.
What can you tell us about that, Ms. Richmond?
When we got there, the flea, we had to have it treated for fleas and roaches.
And how did you determine that?
Because we saw them and we hired somebody to come in and do it.
You had to haul out 2 dump trailers worth of trash. So was the apartment full of junk?
Yeah, there was a lot of stuff around the house and inside the house.
I mean, we could only get so much out in the amount of time. I mean, we'd live there for, 6 years, 5 or 6 years. So there was a lot of stuff and, limited amount of time to get it all out of there. So.
All right. Mr. Webbs, anything you want to tell me?
Yeah, I put the holes in the walls, hanging the flat screen TVs. I did that. I bolted the TVs to the wall. I'm responsible for that. The screen door was always broke. I put carpet in there myself. The house always has fleas and roaches. It started that way. I've rented from them for years. There's always a roach problem. We know that. It's just something we deal with. So they were there when we got there. They're going to be there when we leave. The screens, I know that they put all the screens in. I was right there while they did it. So I don't know. I haven't been there in 5 years. I have no idea why the screens are missing. They did do the screens. Every screen in the house was done. So if they're missing, it's our fault. But I did the holes in the walls, but the roaches were already there. I gave her $1,000 deposit. My lease has been up for 5 years. I paid the deposit myself. That's all I got to say. I think that,
So you weren't there for 5 years?
I haven't been there in 5 years. My lease has been up for 5 years. I've signed a year lease. They let her stay there for 5 years under my name, and now you're trying to say I'm responsible for all the damages. That house was fine when I left. The screen door was never touched. And that's just straight up. I put some lag bolts in the bedroom with a big flat screen TV. I did that. I'm responsible for that. I also did a lot of repairs to that house that were never, you know, I'm a pretty good tenant. Everything was pretty good until I got arrested.
All right, well, and I don't have this case in front of me. So he left 5 years ago and he continued to be on the lease?
Yes.
She's not on the lease at all.
All right, so the lease was in your name and Cassandra just stayed there.
Correct.
Yeah. They've evicted her once already. I already paid her last bill when she got kicked out of the last place.
That's not true, but okay. We're not here to
All right,
discuss.
all right, hold still. Let me pull this original case up. Well, you last signed it in 2019. Apparently the rent had gone up in 65 years. So yeah, it was still operating under a month-to-month lease on the original lease.
Mm-hmm.
I've been in contact with him. I wrote him letters. We had an agreement that she could stay there as long as the rent got paid. I told him to notify me if she started letting the rent. What she did was she let the rent go when I'm about to come home. I'm home in 30 days. She let the rent go and let every utility go, and then somehow got the water turned over in her name and ran everything up to max. And I'm maxed out on everything. I'm reporting fraud as soon as I get home. I'm reporting
Mr.
fraud.
Webb, you were incarcerated.
Yeah.
And well,
I contacted the village. I
The
contacted the village. The water's maxed out, and then somehow got put back in her name without her being on the lease. I don't know how she did it.
water's
Everything's
not.
maxed out.
Just hold on. Mr. Webb, what's your out date?
I come home January 30th. I got like 40 days.
Well, good for you.
I appreciate it.
I'm gonna take the screen door off of here of $30. But the rest of it will stand. 2005-17.
Can I ask you how much of the house was there left that you threw away? That nobody can notify me and tell me to come get my stuff out of the house. They just I have to pay to have the damn house hauled off. You know what I mean? Anybody
Well, it
could
was
call any of the numbers.
$250. I guess it could have been a whole lot worse.
Right. Yeah, but that's also my stuff that I had to pay to get hauled away. You know what I mean? I lost everything and now I got to pay to have them haul it away. No one even called. They got 3 numbers they could have called and said, hey, grab a truck and a trailer, come get this stuff. Nobody called anybody. And I've been in contact with everybody trying to make sure this went smooth when everything went south.
Cassandra told me that you had somebody come pick up your stuff.
She left a bag of crap on the front porch and gave my clothes and some hats. She took everything. She refused to give us anything.
All right, stop.
She took the whole house.
Stop. You all entered into this tenancy. Mr. Webb, you went to the Department of Corrections sometime about 2020. When did you go to prison?
2020.
Yeah, now you're about to get out. Are you going to be at Twin County? Or you're just going to get parole?
No, I'm going to Sturgis. I'm paroling to Center Street in Sturgis.
All right, good for you. But you're going to have to deal with this.
Yeah, I figure. It is what it is.
All right. The damages are $3,000. Let me subtract $30. $3,162. Wait a minute. $2,202 and $167.33 in cost for a total of $2,363.33. Now that's jointly and severally, meaning you could collect all from Cassandra, all from Curtis, or half from each.
I don't mind paying it. I mean, I don't mind taking responsibility for what I'm responsible for.
All right, well, that'll work fine. And you should make payments to Ms. Richmond. You know how to get a hold of her. I don't have, what town are you in right now, Cassandra? Do you have her address, Ms. Richmond?
No, I don't. Oh, I might.
I don't want to put on the live, just a minute.
I think I do have it. I
You
think
do.
All right, and Mr. Webb, you'll be paroling to Center Street and Sturgis with who?
My sister.
All right, Mr. Webb, you're gonna have some adjusting to do when you get here. Lots happened the last 6 years, 5 years technology wise, but you're welcome back to get back on track. But you owe a joint and several debt of 2006, 363.33. Ms. Babcock says she's gonna be responsible for it. If she is, then you don't have to worry about it. If she isn't, they could also come after you for your share of this debt.
So I don't mind pitching in, but I gave them the $1,000 that they took just now for the damages. I was solely responsible for, I lived there before she moved in. Everything I set up. They just took $1,000 of my deposit. You know what I mean? I haven't even been there.
960. All right.
Yeah.
Very good.
That 960 came straight out for me. It had nothing to do with, she had nothing to do with that 960. Plus all the other bills I got to take care of that they ran up while I was here. I mean, I think.
All right. Well, I'm not gonna get into a fight here. That my order stands. You'll each get a copy.
So.
All right, Mr. Webb, we managed to do the best we could with just sound, but thanks to the staff there for helping us.
Yeah, I appreciate it. You guys got to do what you do. I'm sorry, Ms. Richmond.
All right.
You guys
How
were good
about
to me.
when you get back, you don't come see me, okay?
Oh, for sure. Yeah, I don't plan on it. I'm sorry. I just wish that it would have ended different and I could at least got some property, man. This was a whole bad deal, man. Once she got there, I couldn't get rid of her. It's just, I'm just glad it's over. I'm sorry for your damages. You guys are real good to me. You guys are good people.
All right.
So
All right.
I
Good luck,
appreciate it.
sir.
Yep. Thank you.
Thanks, Curtis.
You're welcome.
Oh, man.
All right, I don't want to get in the middle of that, so
I didn't
I'll
either.
get a copy of the order. Thank you.
All right, thank you.
This is file number 241372. It's entitled Portfolio Recovery Associates versus Shannon Roberts. Shannon Roberts is here on her own behalf, and Attorney Cezanne Barta is here for the plaintiff. There was an earlier case, filed 231416 GC, that was filed in March of 2024, and it was dismissed as having gone no progress. This matter was refiled on August 2nd as file 241372. That's the case we're in. It was personally served on Ms. Roberts on September 29th. More than 21 days passed and a default judgment entered on November 7th of 2024. That's the date of this judgment, November 7th. The amount is $2,702.38. So that judgment entered. Even though she was personally served, she didn't respond. The default entered. Then on November 20th, we received a letter from the defendant. It's not exactly a motion to set aside default. That's what we treated it as. On November 20th, which was within 21 days of the entry of the default. Ms. Roberts, what you did is you wrote a letter. That isn't exactly the same as filing a motion to set aside a default, but that's what you're requesting. You sent me a bunch of stuff. In order to set aside a default, the court must find that there's a legitimate reason for failing to appear, and you're supposed to file what's called an affidavit of meritorious defense to show that there is a defense to this. So we're kind of playing a little fast and loose with the rules, but we often do that with pro per defendants. Mr. Barta, what's the plaintiff's position here?
Your Honor, plaintiff's position is that to set this aside, you have to have a meritorious defense and good cause. I don't believe there's good cause. However, sometimes I bypass good cause and I go look at the meritorious defense myself to see if there's any plausible reason that this was paid or any proof that it was paid. And then I would have no problem setting it aside and then doing my due diligence, sending it to my client to find out what's going on. However, in this case, Your Honor, I just don't see how this was paid. The letter that was submitted by Ms. Roberts it looks like she circled something on her bank statement showing that it was paid, but it's a $1,300 payment. And that $1,300 payment is not even to the debt in question. It's to a Credit Corp Solutions, which it has no bearing on this. This was, unless she's saying, unless it's accompanied by a letter from a Credit Corp Solution saying that this is the debt in question and this is the amount that you can pay to resolve it. But just circling a payment of $1,300 to a Credit Solutions doesn't show us that this debt was satisfied and or paid.
That was the first collection company that it was sent to.
Just a minute, Ms. Roberts. I'll give you a chance to speak. You don't just blurt stuff out. You've been to court enough times. You should have a little more information on how this works, but I'll let him finish, then I'll let you speak.
So that is concerning to me. And it's also concerning to me that this debt was sent from, if you look at the bill of sale attached to our complaint, this PayPal Synchrony Bank account was directly sold to Portfolio Recovery Associates on January 30th of 2023. So it doesn't even show that there was a debt collector in between that had this account or was trying to resolve this account. It would have been Synchrony Bank, PayPal directly, and then it went directly to Portfolio Recovery Associates in January of 2023. So any payment made in February would have had to have gone to Portfolio Recovery Associates and or to plaintiff's attorney, but I just don't have any answers as to this entity which she circles and has $1,300 paid to.
All right, Ms. Roberts, now it's your turn to speak. What would you like to say?
September 29th, 2021, my husband died and I lost 2/3 of my income. I couldn't afford any more credit cards. So when my farm payment came that I split between my brother and I in 2022, which is only $10,000, all my credit cards had already been sent to collections. And I've already been in here for the Discover card that I ended up having to pay the entire balance for. And the reason it was Discover that I had to pay is because I did not have enough money and they would not settle. By the time I got my check in February, all my credit cards had been sent to collections. That I had 2 PayPal accounts. And I paid over $2,000 on the second one, and I paid the 13 or whatever it was because they were in collections. That company they got it from was the first collection company, and I settled it. I settled all my credit cards except the Discover card, which I've already been taken to court. Now, all the payments, all the amounts that I did not pay off with the settlement, this isn't my first, I have 3 more that they're coming after me after the balance, after I settled with them. And I called PayPal and I sent all of that to you, Your Honor, and the other bank statement showing the $2,000 I paid on things. And according to PayPal, after I settled with that Capital Corporation or whatever it's called, I have no debt showing at PayPal. They don't even show that they have sent anything to Portfolio. And I was on the phone almost 6 hours with them. And I sent you all those notes, Your Honor, with the phone number and the agent's names I spoke to.
Well, we don't then mount our own private investigation of it. You had so many debts and you were trying to do the best you could to resolve them all, but it doesn't appear this one was resolved. They don't show that any payment was ever made on this PayPal account. And just because you send a bank statement with a circle on it that shows money was paid to someone, it didn't go to this account according to the plaintiff. I'm not, anyway, it's based on your belief about what someone told you at some point several years ago. But this debt, there's no satisfaction of judgment that was ever filed to show this debt was resolved. It's outstanding, and your payments may have gone to something else, but they didn't appear to go to this. Mr. Bart, anything to add?
I don't, Your Honor. You've said it, you know, unfortunately, you know, I can't, well, it's hard to explain, but if this account was sold in January of 2023 to Portfolio Recovery Associates, then the payment would have had to have been made to Portfolio Recovery Associates. If in fact a $1,300 payment was made to a different entity, I wouldn't be able to figure that out because I'm not part of that entity. I don't have a relationship with that entity. Portfolio Recovery doesn't have an association with that entity. The only person that would be able to find out any information about what that $1,300 was paid to would be Miss Roberts. And I would behoove her to, moving forward, maybe get additional information and maybe refiling this when she gets that information or sending it to me so that we can figure some stuff. But just from what I'm looking at, there's, you know, the Portfolio Recovery's had the account since before the time this $1,300 payment was made, and they don't show that any payments have been made. So the only thing I can go by is that there is a balance and still doing owing, and that there have been no payments made towards this account.
This is let's assume everything you're saying, Ms. Roberts, is correct, just for the sake of this argument, that you paid some money to a debt consolidation company to resolve this debt, but they didn't pay the owner of the debt. Maybe they took your money and went to Hawaii. Maybe they applied it to a different debt. Maybe they're still holding on to it. But even if your argument is correct that you paid some settlement money to another company to settle this, it hasn't been paid to the plaintiff. And as Mr. Barta said, maybe you can sort it out with them and find it or apply it to this debt. But there's something called a satisfaction of judgment. When a debt is resolved, they file a satisfaction of judgment to say that it is in fact resolved. There is no such document here. You got something somebody told you. So let's say you gave it to your cousin to pay this and you thought it was resolved and your cousin didn't pay it. You still owe the debt. That's the circumstance here.
Your Honor, it wasn't a debt consolidation. I called each collection company directly and settled with each company. And because the emails are over a year old, AOL or Yahoo automatically deletes them. So I don't have the contracts. Because in November of 2022, I settled all the rest of them when my cousin sold his house that I had to move up here from Iowa, and he gave me 10 grand for moving him, and that's what I settled the rest of them with.
All right.
What I'm suing for is the balance that the settlement didn't pay.
All right. Then I find that you owe it. If you can find something further to show there's something been paid or otherwise, but at this point, your motion to set aside the default is denied. And even under your explanation. It's the balance of what was left over. So,
But what does it mean then when I settled the debt with the collection company?
it doesn't mean anything as far as Portfolio Recovery Associates is concerned.
So I wasted all my money. I should have just let them take me to court like this.
I don't know the answer to that. Now, you're not under oath. You wrote me a letter with a bunch of random stuff. And as I said, we don't do our own investigation where we call these companies. I don't find that you've established a meritorious defense. I don't know why you didn't answer it in the first place. That's the other thing.
Because I was in the hospital having a back fusion.
Yeah, that's right. That's what all those pictures were for. So I guess that is a just cause for not responding. So I'll grant you that one, Ms. Roberts, but I do not find a meritorious defense. Mr. Barty, do you wish to speak to her any further about other advice?
Your Honor, I'd just like for her to know that this account in 2022 was charged off at $2,575.30. And that is still the amount that's due and owing, so that any payment that was made was not attributed to this account. So not $1 of that payment made it towards this particular credit card ending in 9658. It's very important to make sure that if she does some due diligence to find out her account number ending in 9658, I would go back and, if I were her, try to figure out where that $1,300 payment went to and for what account.
All right, I've signed the order. When they charge it off, if you say, all right, do I have any debt to Target from my credit card? It would show no. Target charged it off, but they didn't forgive it. They then sold it to another entity to attempt to collect on it. So it may have shown of no debt to PayPal, but PayPal charged it off in 2022 and then sold it in December of 2023. Or January of 2023.
So even though I settled the accounts, they can still come after me for all the rest of it.
Well, apparently you didn't settle this account. They charged it off saying, well, we're not gonna be able to collect this debt. And then they sold it to a company to collect the debt. So the answer is correct. And Mr. Barta's advice that you find out where this $1,300 went. My guess is it went to another account and not this one. All right, I've signed the order. That completes this.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're gonna start bringing people in person. People gonna learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.